Monica, I just took a second to screenshot everything you did and sent it to YouTube. I'm just going to send it to them every day because somebody contacted me through an email. So now I have an actual person. I'm just going to keep sending them screenshots. But have you tried smiling? A little bit. Maybe that's the problem. Sorry, I'm talking again. That poor cat. I've never seen... I don't know if she's a guardian ad litem. I don't know what her title is. Okay? But Dad has custody of the children. They're 2 girls. And Mama's allowed to call and talk for 15 minutes. And those calls are recorded and those calls are monitored by a person. Oh, well, a bunch of people because they're in court. I don't know the title of the person who monitors those calls. But I do know this person well oversteps her bounds and slaps down this mom repeatedly verbally in court. I'm not saying she's wrong, but she pretends to be the judge. It's harsh. I'm not saying she's wrong. I'm not. And then another person, and again, hopefully they say what their titles are, because I can't remember. She joins in, and she's much more professional. But this first woman, just wait. This mom gets nailed. She deserves it. None of these people are wrong. It's just not their place. Mom's late. We're going to see Mom come in late. And we're going to see this person who monitors the phone calls continually slap Mom down for being late for court. Instead of the judge. I'm not sending that to YouTube. I don't need them to know the comments are okay on the phone, because they'll just say, oh, problem solved. Tell them to use their phone. I made a little video of the conversation I had with YouTube yesterday. I forgot that I was muted the whole time, but I can add my voice later, but it's crazy what they're saying. They're saying they need screenshots of the deleted text messages. They're saying everything they said, oh, please just go look at this article. It's because you're in top chat. No, it's not. It's because you don't have live chat enabled. I said, well, then how am I sending you screenshots of my live chat? It was crazy. Hi, Rose. Oh, she's bad. This mom, I would put it down. This mom is the worst we've seen yet. What she does when she knows she's being watched. So who knows what she does when she's not being watched? Well, we know that.
But she did sit in on a couple of sessions with Julie, the older sibling.
Okay. So is it accurate to say that Julie is primarily your patient?
Correct.
And any visits that you had with Vivian was just in relation to your appointments with Julie?
They do say her title. I was wrong. She's the counselor.
That's correct.
Okay. And tell the court, if you would, what history you obtained in regards to Julie.
Well, like I said, I come to know Julie back in June of 2025. And what I've been able to see so far is that we're dealing with, she's 9 years old. She's very much developmentally delayed, speech delayed. I would say she's about on the level of someone in kindergarten, although she is in fifth grade. She's just extremely delayed, withdrawn, and she's just nowhere current to the level that she should be on for a fifth grader.
And what do you attribute those delays to?
I'm concerned that the delays have a lot to do with the social environment.
Thank you, Jude. Thank you.
That she was in with her mother. I feel that the mother was able to use the vulnerabilities of a child, such as Julie, and
Thank you, Jenny. I appreciate you guys. I really do.
And this created more developmental delays. And just to elaborate on what I mean by that is that when you're dealing with someone that's cognitively and developmentally delayed, they become more emotional and they can regress much easier. That is why we were focusing more on Julie versus Vivi, which is the younger child, is because Julie was much more emotional, withdrawn, set back. She just displayed many more behavioral health issues than Vivi did.
Have you had any, did you obtain any information from Mr. Towns regarding Julie and/or Vivi?
Yes, Mr. Towns was concerned that she was not attending school as she should be. I don't have specifically in this particular note that I have right here if he was referring to her last year or just in general over the years. That would be something we could ask him. But his concern was that due to the mother being unstable, that the children, and I will specify Julie because that's who I worked with, Julie was not attending school as she should, and that she was actually a babysitter, that's quotated in my notes, for some of the other siblings that were in the home. After meeting with Julie on several occasions, obviously I can't prove that she was a babysitter, but I can say that from my years of experience that this child did not seem to be where she should be for her grade level. And we know that we're going to run into kids with cognitive delays and developmental delays, and everyone's not going to be where they need to be. But for her to be somewhere on the line of a first grader and a kindergartner when she's in fifth grade, it makes me question, she has a speech impediment. Was she getting speech the way she needed? Was she getting after school tutoring? Was she going to school as she should? I do know that while she has been placed with Mr. Towns, I have asked him on several occasions, and this kid is now, Julie is receiving tutoring. She is in speech. She is going to school on a daily basis.
Is Julie a child that is easily manipulated?
Very much so. Again, that would fall under the cognitive and developmental delays and what we are.
She's the social worker, the counselor. She says what her job title is in a minute. She's not a psychiatrist or a psychologist because she doesn't prescribe anything. She's one lower.
Working with here, unfortunately, due to her having those type of behavioral health symptoms, that does put a child such as Julie in a situation where she's just prone to be more vulnerable.
What changes have you noted in Julie, or progress have you noted that she has made since you initially started treating her to now?
Since I've initially started treating her, I met with her in June. Obviously, she was withdrawn, shy, timid. In July, there was already a little bit more improvement. However, she was still coming in with a constricted affect, that's not abnormal. She doesn't know me. It takes a minute to establish rapport with a therapist. By August, she was just coming in with a smile on her face for the first time. She was not as shy or timid. She would come in and we were able to process like just some of the basic feelings, getting her to start communicating and verbalizing different emotions. And she started making some progress.
In the previously, you had, before the most recent months, but initially, back in 2025, you had made a recommendation that there not be contact or phone contact between the children and their mother. Is that correct?
That is correct.
Okay. And thereafter, the guardian ad litem made a recommendation to allow some phone contact, correct?
She did. That's correct. We actually, Miss Anderson and I conversed on October the 14th, and I was still hesitant. I'll be honest with you, from my years of experience of doing this, I was still hesitant that she needed contact with these children at this time, because honestly, I wanted to see on my end, my recommendation was that she receive a psychological eval and that us proceed from there on the contact with the children. However, we did try to meet in the middle on this because, again, I'm not trying to keep her from her mother either. I just want to see that it's healthy communication. So we did agree, and I say we agreed, solely mine is recommendations, obviously. But my recommendation then was that if we had to give the court something, that please, let's not start off with any more than a 15-minute conversation per child and go from there. And
that's all Mom's getting. Mom is only getting 15 minutes. And wait till you hear the destruction this woman does in 15 minutes.
If we could see that she could positively engage with the children, then by all means, let's move to 30 minutes and then obviously go from there with some maybe in the future physical visitation.
And like it keeps piling on. So we're going to hear a little bit from her, and then we're going to hear more, and we're going to hear more, and it just never stops. Until the hearing stops, it doesn't stop. We learn more and more of what she did. I'm on my own planet.
So the order was put in place allowing the phone contact and some limited visitation in January of 2026. Is that correct? Is that your understanding?
Yes, my understanding was that only the phone call was put in place with a 15-minute phone call for the children, and it was later discussed as well that we make sure that she's doing 15-minute per child, because I did come across after listening to some of the phone calls that we were tending to favorize conversing with Julie, the older child, over she didn't really want to have much contact with Vivi, the younger child. So we then specified, Mr. Townsend, I talked about it, and I believe he then spoke to you, Ms. Shook, or the guardian ad litem about, let's specify 15 minutes per child.
Hold on just a second. I'm going to let Ms. Hilliard in, but I'm going to tell her we've already started.
Here comes Mom, finally.
Ms. Hilliard, can you hear me and see me?
Yeah. Can you
All right,
hear
Ms.
and see
Hilliard?
me?
I do. I see and hear you perfectly. I wanted to let you know that we have already started, and you will have a chance to ask Ms. Walsh some questions in just a minute, but you may proceed. Ms. Shook, go ahead.
Okay. I've lost my train of thought. Give me just a second, Judge.
All right.
We were discussing that in January of 2026, that Ms. Hilliard got the ability to have phone conversations with the children. Have you noticed any differences in the children or effects upon the children, good or bad, from having that telephone contact with their mother?
And since having the telephone calls from the mother, when Julie, I'm sorry, not Julie, but when I spoke with Mr. Towns, he actually called me a couple of times because he was very concerned because he said that Julie was starting to regress. And I asked him, this was on December the 4th. I said, can you specify on how she's regressing? And he said that since conversing with the mom on the phone, Julie and her sister are withdrawn after the phone calls. He then said that they would ask questions like, why do we live with you? Why are we not getting to talk with our mother? And things of that nature. And then there was some other phone calls as well about regression, such as on December the 11th, the biological father called and was concerned and said, look, she's starting to backtalk. She's walking away when I speak to her. He said this did not begin until after the phone calls. He said that his daughter was spending time at a rescue ranch,
Hi, Beck.
which she enjoyed very, very much doing, and that the mom called the rescue ranch, sent documents to them, and then proceeded to send all kind of legal stuff to a rescue ranch. He said that she would constantly ask the kids, are the cameras working? And that he was concerned because she was saying things to give the kids false hope, such as, we will see you at Christmas. I received another update on regression on February the 17th, and he said that it's getting out of control. Julie continues to act out, especially now after every phone call with the mother. She will state, I don't have to get off the phone. You can't tell me what to do. I have a voice to choose what I want to do. He said that Julie then has started back talking and saying things such as, you make me study too much. Mom doesn't make us study like this. I should have a phone. I should have Snapchat. All that's quotated. Mom calls you a psychopath. Before the phone conversations, he
I think they are both under 10 years old. I think. We're going to find out.
noted that she would be happy and focused. After the phone conversation, she becomes really withdrawn and agitated, and her voice becomes whiny like a toddler. She often will then, after the phone conversations, want to be by herself and go to sleep. And he said it's gotten to the point that she becomes more aggressive with her siblings. Again, that last contact was on February the 17th regarding that regression.
Did you have an opportunity to listen to the recorded phone calls between the children and their mother?
I did.
Tell the court about what your thoughts are on whether those phone calls are appropriate or not.
I do not feel like the phone calls are appropriate. Again, I'm speaking from clinical experience here. The phone calls are basically as if the children are being interrogated. They're not coming from a source of genuine love of, how was your day going, baby? How are you doing? How was school? We tend to want to interrogate the children on the conversations, even though we know that they're being recorded. Rather than asking them how your day was, the dialogue seems to be, in my opinion, rather unhealthy. We ask the kids about cameras constantly, or are the cameras up? She asked the kids, will they testify in court? Most of the dialogue actually is about court. And I have a problem with that as a therapist, because I don't feel like the kids should be put in the middle of this court case at all. It is highly inappropriate. These phone calls, in my opinion, should be about the well-being of the children and how they are doing. We should not be discussing the court case with these children, especially when these children are 10 and under, in my professional opinion. Furthermore, it's in the recordings where she wanted to get the kids, she tried to get the kids to write down her phone number, and told them, you can call anytime you want to call. In my opinion, I'm not an attorney, but that is showing that she can't comply with a court order. She provided false hope that the kids would get to see her at Christmas. I did listen to that on the recordings. She went on to bash the father, which is not the place or the time to do it on 15-minute conversations with your kids. And she told them, he never bought you anything for Christmas. These kids do not need that. I'm not here to say that they don't need both of their parents in their lives, but we've got to get to a place where we can have some healthy dialogue and communication with the kids before I feel like she should go further with her children.
In case you're wondering, Mom is not hearing any of these words. Guardian Litem's going to come up next. Mom's not going to hear any of that either.
How do we get to that point? How do we get Ms. Hilliard to understand what's appropriate conversation and what's not?
Electroshock therapy.
I think that's a good question. I obviously have not assessed Ms. Hilliard. I think that she needs a full, intensive psychological evaluation ordered by the court. And I think, after that, maybe we can get the answer to that. But I mean, I don't even think it takes a clinical therapist with with the information that most of us listen to on these phone calls to see that this is just highly inappropriate. And it shows that we're trying to alienate these children from their father, and we don't need that either. We want both of the parents in their lives. Again, in summary, I say we just want it to be healthy.
So do you think there needs to be a full psychological evaluation and a review of the report before she has any further contact with these children?
In my professional opinion, I do.
Okay. And obviously, would part of that be for her to follow and comply with any recommendations as a result of that evaluation?
Correct. Yes, ma'am.
Okay. You prepared 2 different letters regarding this case on what you felt was appropriate as far as contact with the children. One was back on September 16, 2025, and the most recent one on February 9, 2026. Is that correct?
That's correct.
Judge, I would tender both of these into evidence. I'll tender.
Martha, are you feeling okay today? I have to know. Are you in pain?
The September 16th as plaintiffs 1 and the February 9th as plaintiffs 2. I was not aware that Ms. Hilliard would not be present in the courtroom, so I don't have it electronically in the electronic format to send her a copy at present.
But you can certainly, right?
Pardon?
But you can.
I can.
Not right now. I got you.
She received a copy of the February 9th one with the previous email that she was a party to when I got the emergency order.
All right, well, I will admit them and just make sure that Ms. Hilliard gets an email copy of both of these.
Yes, sir.
I was watching some videos. Total betrayal of dads. There's like these little toddlers, like little 3-year-olds. Mom's sleeping, and dad gives him a belt or a shoe, and they walk up to mom, and he's like, yeah, hit her, go ahead, hit her. The kid will hit the mom, not hard, it's a 3-year-old, you know what I mean? Just, or with their hand, and then they both go to run out of the bedroom. And the dad will run out, shut the door. And the little kid is like pounding on the door, and then they turn around and see mom. And they all act exactly the same. They all start just crying and crumpling to the floor. Bobby, I'm so sorry. Don't do that. That's traumatizing.
Make a note that we got to send that. Has Mr. Hilliard, or excuse me, not Mr. Hilliard, Mr. Towns incurred expense in getting counseling for Julie?
Yes, he has.
Can you tell this court how much money he has spent trying to get counseling for this child thus far?
I don't have the exact figure in front of me. I can tell you that the initial intake was $160. She did approximately 10 sessions. The follow-up sessions are $125. He always pays on time. It was $400 for me to appear today, just due to, I have a thriving private practice, thankfully, but it's hard for me to get away. And so his expense today was $400. He had no problem. Actually, the day that my assistant sent the invoice, he was able to go ahead and take care of that balance. He is completely paid up on all of his accounts, and he's never been behind. He pays for every session at the time of that it's due.
That's crazy. We never hear that. That's crazy. The guardian ad litem is going to come up and say, Dad paid her too?
If I'm capable of doing math accurately, it would seem that he has spent approximately $1,810 for Julie's counseling. Does that sound accurate?
It does.
Okay. Is there anything further you want the court to be aware of in regards to this case?
No, ma'am, I can't think of anything.
Okay. No further questions at this time, Your Honor.
All right, Ms. Hilliard, do you have any questions for Ms. Walsh?
I do.
All right, go ahead.
Ms. Walsh, you're a licensed clinical social worker, correct?
That's correct.
Are you a medical doctor?
No, and don't claim to
Are
be.
you,
This is mom asking these questions. She starts off really good. This is mom.
are you a psychiatrist?
No, I do not prescribe meds.
Have you ever conducted a full psychological evaluation of my daughter, Mary Julianne Towns?
Yes, I completed a biopsychosocial on your daughter when she started counseling.
And when was that date that she started?
We actually said that day earlier. You were not present, but I'll be glad to refer back to that for you. Give me one moment.
Please and thank you.
She started counseling, your daughter started counseling on June the 19th
Of what year?
of 2025.
Do you want to know why mom is pro se drunken? Do you want to know why? It's obviously because dad took all of the money. She has no money because dad, the abuser, dad took it all. Glad you asked.
Okay, do you recall the conversation when I first contacted your office and you claimed that Julie was not a client of yours, that Robert had brought her by, but you were not going to see her? Do you recall that conversation?
I don't, because you didn't speak to me. I have other employees that work for me, and you did not speak to me, Mrs. Hilliard. And furthermore, without a subpoena or some type of professional legal documents, I can't disclose who is a patient and who is not. That's just HIPAA for you. That's not anything against you or anyone else, but I mean, for all I know, Jane Doe could be calling me, and I can't disclose over the phone who is a patient and who is not, because I can get sued for that.
I work in medical. I'm aware of HIPAA. I also am her mother, and I have my parental rights remain. There is no evidence of neglect, abuse, harm, and all my rights have been stripped of me. But the total number of sessions you say is 10, correct?
Yes, that was an approximate number of sessions. We discussed that earlier as well.
And they started in June.
Correct.
Each session lasts how many minutes?
Each session lasts approximately an hour.
You have not treated Julie on a long-term basis, correct?
It depends on what you would call long-term. I have been treating your daughter since June of 2025.
You're the clinical social worker. It's a yes or no question, please.
Again, it would depend on, I've been seeing her since June of 2025. Do you consider that long-term? You can make your own assumption on that, ma'am.
10 sessions, no. But did you independently seek out this family?
I did not.
And you didn't receive a joint parental referral, correct?
I did not.
You did not personally speak with me, the mother, before forming initial impressions, correct?
I did not, and I do not have to, because you didn't have custody of your child.
Have you ever conducted a clinical evaluation of me, the mother?
I have not.
Have you ever administered any psychological testing to the mother?
I have not.
Have you ever observed myself, the mother, and my daughter Julie together in a therapeutic setting?
In a what setting?
In any setting. Have you ever?
Yes, actually, I have not physically observed you, but I have listened to several phone calls between you and both of your daughters. Several.
Okay. Any opinions you hold about mother were formed without a formal evaluation, correct?
That's why I'm requesting that you receive evaluation.
My comments come through. All of them, because I just pause it and say it out loud. You guys can call in. Call in to me, and then you can just say whatever you want. And then your comments won't get eaten.
Your opinions are based primarily on limited sessions that you described, these 10 sessions. That's where you have come into this evaluation. Your, what did you call that procedure you used, a biopsychotic? What was this?
No, it's not a psychotic. It's a biopsychosocial assessment. And that is a treatment tool that we use when we first assess a patient in a psychotherapy setting.
You did not review the mother's Tennessee records prior to forming opinions, correct? My psychological evaluation I had here in Tennessee?
I did not.
Did you not review Julie's prior school or therapy progress in Tennessee, because she was thriving? Boy, she was thriving. Her and Vivi were thriving. Did you review any of those records?
I wasn't actually
I am also thriving.
informed about some of those records. Yes, I was. And if she was thriving, I don't understand how she would be on a kindergarten level, but I'm trying to keep it to a yes or no, ma'am.
She had a program, it was a one-on-one program designated for Julie. She's been behind since COVID. When COVID hit, she was in kindergarten learning the fundamentals of everything. And it
I'm
really
sorry, I'm not
affected Julie.
understanding your question here. Are you asking me a question or are you forming an opinion that you would like me to know about? Because I'm here to answer questions.
Move along.
And if
You did not
I'm
conduct-
wrong on that, please, the judge can definitely correct me.
We can move forward. You did not conduct standardized custody testing in this matter, correct?
No, I was not hired to do so.
You did not administer a full psychological battery to Julie, correct?
A what?
A full psychological evaluation.
Yes, I completed a biopsychosocial on her. Did I complete psychological testing on your daughter? No, I did not, because I am not a psychologist. I am a clinical therapist, and there is a difference between the two.
Yes, that's what I'm trying to establish here. You did not perform a parental fitness evaluation of either parent, correct?
I was not hired to complete a parental fitness test for either parent.
So this was a role that was therapeutic rather than forensic, correct?
It was therapeutic based on what happened to your daughters.
Okay. And the therapeutic impressions and forensic custody opinions serve different purposes, correct?
The therapeutic opinions serve what we discussed about prior to you coming on this phone call, because you were tardy upon the phone call.
Moving forward, a mother contacted your office seeking information about her child, correct?
A mother called my office.
I contacted your office seeking information about my child, Mary Julianne, correct?
Yes, you did. You called approximately 20 times a day, along with bashed me on Facebook, slander actually, and did other things. But moving forward, please.
No, that's a lie. That is completely improper response, because I attached to one of my filings where I called repeatedly. That's after you made your statement that was full of lies. I called repeatedly that day. Yes, because there was an emergency hearing set in a couple days. I did not harass you. Every effort I have put forward has been in good
Ms.
faith.
Hilliard, get back to questions. You
Yeah.
can tell me all that later. Get back to questions.
Okay. I requested records and clarification.
See, Rose, I told you this therapist oversteps herself big time, but she's right.
In writing, correct?
You requested it, but I did not know who you were, if you were who you said you were, and I was not going to release records to someone without the proper subpoena or what was needed for me to release the records.
But I requested records and clarification
Yes,
in writing.
you did request. You definitely you did request.
Thank you. My emails were professional in tone, correct?
Yes, I think ChatGPT helped you a little bit, but yes, they were definitely professional.
Did you file any police report regarding me and this claimed harassment and all?
No, I did not. I did tell some attorneys about it though, because I'm not the only one you did that to, but I don't think that's related to this. So let's stay on topic here about your children.
Yeah, moving forward. You didn't seek a protective order against me, correct?
A protective order against who?
The mother, Mary, me.
No, I did not.
Okay.
Why would I seek a
Would you
protective order?
agree? We're trying to move along in what you're claiming. This is y'all's whole case is claiming that I'm unfit and I'm harassing you even. A lady I don't even know but has made all these opinions of me. Yeah, it's relevant because this retains to me as a mother. My highest honor is my motherhood. So yes, this pertains to this, absolutely. But moving forward, would you agree your involvement with Julie has been limited in duration?
Mine was my Donkey Kong store back in the day.
I don't think it's been limited. I think that I have listened to the phone calls as I was asked to do, which was numerous phone calls. between you speaking with Julie and Vivi. So no, I can't answer yes to that because I do not feel that it was limited. See, those phone calls, Ms. Hillard, are just as important as your daughter coming and getting in those psychotherapy sessions, because that allows us to see how you interact with your child, even when you know that those phone calls are being recorded.
And to your understanding, is there any evidence of neglect or harm that has caused, where we are today?
Yes. Again, I'm sorry to go back to this again, but and sorry, Judge, I'm definitely not trying to be disrespectful, but this was information that was discussed earlier, and I'll be glad to repeat it. There was a good bit of it, but yes, I certainly think. Yes, there's evidence. If the judge would like me to repeat it, I'll be more than glad to.
No,
but
I
it's
heard it.
pretty extensive.
Well, hold on, Ms. Walsh. I heard you the first time, and you're not going to repeat it. That's Ms. Hilliard, for whatever reason, didn't get logged in, but you do not need to repeat it. Do you have any other questions, Ms. Hilliard?
That's all.
All right, anything else?
Not with this witness, Your Honor.
May this witness be excused?
She may.
All right, Ms. Walsh, thank you for your time. You are excused, and you are free to go about your business and terminate the connection. Thank you very much.
Okay, thank you.
If you've ever loaded your dishwasher, you've played Tetris.
All right, who's next? Ms. Shook?
Judge, I would ask Ms. Anderson to provide her recommendations.
All right. Go ahead, Ms. Anderson.
Yes, Your Honor. Since the last time we were here in September, I was able to move forward and interview all of the witnesses that were provided by Ms. Towns. The witnesses that were provided by both parents are what you would typically expect for witnesses. His witnesses says he's a great daddy, she shouldn't have the kids. Her witnesses says she's a great mom, he shouldn't have the kids. There was a lot of information that was given that predated their divorce in this instance. We went through, we spent over $100 on ORR records based upon some of the allegations that were in this case. So we got incident reports, we got records. I have met with the children multiple times at school on random days. Mr. Towns didn't know, Mrs. Hilliard didn't know. There were random days that I met with them. I met with Miss Holly, who's also the school counselor, multiple times at school. I sent off for records from White County schools. I myself went and got the children's school records from White County. I got 2 sets. I got a first set, and then they had to go to the Board of Education office to get Julie's IEP records for me to send those to me. So I did get those. I reviewed those. I reviewed all of the records from Julie's counseling sessions with Ms. Walsh. I actually talked to Ms. Walsh multiple times. Initially in September, I got a letter from Ms. Walsh that recommended no contact. Ms. Walsh and I talked after we had interviewed witnesses. I had talked to the kids. She and I had talked in October, and I did, over Ms. Walsh's recommendation, talk to her about some sort of contact. How is a way that we can have phone calls with these children so that they can let's reestablish this relationship that had been not there long since before I got in this case. I did make that recommendation of the 15-minute phone calls after talking to Ms. Walsh and us kind of hashing it out and coming to a halfway point. She did continue to have reservations, even with me kind of saying, hey, we need to do these phone calls, so long as the phone calls were appropriate. I have listened to all of the phone calls. They were all sent to me. It is clear in the phone calls, Your Honor, Ms. Hilliard knows they're being recorded. There is inappropriate conversation throughout the phone calls. Ms. Hilliard refers to Mr. Towns as the children's sperm donor. With the children on the phone, there's conversation about Ms. Shook, there's conversation about court. But what's most troubling in the phone calls are their incidences, for instance, the daddy-daughter dance. There is a phone call where Vivi is excited about her dress for the daddy-daughter dance, and all she's trying to do is talk to her mom about this dress and going to the daddy-daughter dance. And that is met with a never-ending conversation about Mr. Towns has never bought you anything, he doesn't buy you clothes, you don't have this, that, and the third. It's not even passive-aggressive phone calls, they're just aggressive. The problem with the phone calls with Vivi, not so much so, because she has a little bit better cognitive ability. She's just kind of a carefree, it is what it is type kid. And there are times in the phone calls where Vivi herself redirects the phone calls. And that is a problem when the child is redirecting the conversation. There are times in the phone calls where Ms. Hilliard spends time talking about things that the kids would be engaged in if they were in Tennessee. There's discussion about those things not existing here in Telfair County. It's kind of like telling a child that you're at, and this is a poor example, but here's an example, telling a child that you're at Dairy Queen, so the child would want to go to Dairy Queen. Well, if you were here, you could go at Dairy Queen. It's that kind of conversation in the phone calls, which is what makes the phone calls appropriate. There are times, and I will say that Ms. Hilliard in the conversation is fine. But once there is a trigger that happens, if the children particularly noted, if they say something about what they like about being here, that just sends these conversations off on a tangent and in a different way. What's most concerning about these conversations with Julie in particular is Julie's cognitive ability is that of a kindergartner. She is in the 5th grade. I will say this, when I got her IEP from White County, I have never seen an IEP, Your Honor, where a child has a reading fluency that landed in the less than 0.1 percentile. And that is where her reading.
Oh, this poor kid. Bren, you're right. V, when you walk in the chat, it lights up. That man is stupid.
Once it was.
Your ex.
I have never seen that before, and I have looked at a number of IEPs and records. When she started school in Telfair County, she did test, but there was no documentation from the schools. So they had Telfair County kind of guessed at what services she needed based upon her scores. They did actually provide her the services that she in fact did need. Nobody provided a copy of the IEP. Ms. Hilliard went to the IEP meeting. She didn't sign it. I'm not sure if she gave it to the school or not. They got the IEP from me, so that they could then give her the appropriate services based upon the IEP. The school didn't even know the child had one previously done, and they were preparing for a new one. They got that IEP emailed from my office. Since that time, when Julie first tested in, just so the court understands the concern about her cognitive ability, her Lexile score was a 35 in the 5th grade. To give the court kind of an example, my son is 7, and he's got a 549 Lexile score, and he's in the 1st grade. To be on average, she should be at about a 700 right now. As of, I think it was last week when I met with them, her Lexile score has increased, but it's only a 335. She is.
That's amazing. Just to go from so low to 335 is amazing. This has only been a couple months. January, I think. December or January, I think. So, yeah, Mom said she was thriving. She sure is.
Like talking to a kindergartner. There was a phone call wherein Julie was working on her sight words. She was extremely, talking about the sight words, and Mom's just kind of grilling her. Every time I talk to y'all, you're doing a sight words, and the child is clearly learning, and you can tell that she's excited about this, and it's more of an interrogation about the sight words and why are you doing these sight words and how many do you have to do, and every time I talk to you, you're doing these. There's inappropriate conversations. In one conversation, Vivi actually asked her mother, is she coming to Telfair County to see her? And Mom says in response to a 7-year-old, I'm never coming back to Robert Towns' house again. Do you remember when he slashed my tires and he beat on my windows? And that's the kind of conversations that we're having, which is why these phone calls are not appropriate. For whatever reason, they cannot stay on the normal in a 15-minute period. The normal things that you would expect to talk to about the kids. Like I said, the school dance, the daddy-daughter dance was a big to-do here recently with the children.
Mom has 3 other kids in her home. 2 of them, these 2 are with Dad, and then Mom has 3 other kids in her home.
them clothes. He doesn't have clothes. We're getting reports from school that they look all kind of lazy. Why haven't, it's February and the kids were actually talking about the snow days. And there's a conversation about why they haven't gone and got summer clothes and things of that nature. So I say all that to say the problem that we now have is Vivi has the ability just to say in her mind, okay, this is not going the way it's needed to go and redirect it. Julie does not. There was conversation at one point in a phone call that I listened to where the child was basically being insinuated to that she doesn't see Miss Walsh. And in fact, when I met with her, I asked her about Miss Walsh, who I know that she sees. I've read her records. I was confused for a minute because Julie was telling me she didn't see Miss Walsh. Like, that is the kind of effect these phone calls have on her. She doesn't have.
Her mother told the kid, you don't see Miss Walsh. And even though the child clearly sees this woman, she says, no, I don't see her. I don't see her, and believes it. Because she doesn't understand. She cannot think, the poor child.
Have the ability to differentiate between what is truly true and what is not. And I think part of that is because now Julie's testing, it has to be given to her orally in every class where she can see whoever's done it, and we're doing this stuff over the phone, which is leading to these issues. I reviewed all of the records. She has been seeing Miss Walsh since the 19th, and then I got that second letter from Miss Walsh, and I'll be honest, I kind of felt like a gut punch, like I jumped myself out there on a ledge to kind of encourage this relationship with a mom after I had a professional with the letters behind their name says this doesn't need to happen, and now we've got a level of regression. The school did report earlier on that some of the issues were Julie would be disrespectful to Mr. Towns when she was seeing him, not so much Vivi. She struggled a little bit. When I saw her this time, she's got friends now. Just the stuff, the progress that we would want to see, but at times there is some regression to some baby talk, things of that nature. The phone calls, the children just know that they're supposed to get off the phone in 15 minutes, but I think there's some belief that Mr. Towns is hanging up the phone. I did meet with the children and talk to them about the phone calls, and they tell me that they hang up after 15 minutes. They know they're supposed to end. And there are some phone calls where the conversation has gotten kind of left, and the child, Vivi, will just hang up herself. You could tell she's trying to just stop it and hang up. There was one conversation where there was a back and forth, and the poor child was confused about, it's 15 minutes, it's time for it to be over. Ms. Hilliard had a whole section about she's their mother, they can talk to her whenever they want to, though she's got freedom of speech, and then there's a back and forth about, well, do I get off the phone? Do I go tell dad? Do I get off the phone? And it's that kind of confusion for these little kids. They are very much being drug into the middle of it. There is a lot of conversation about court. I'm not sure that these children know who Miss Shook is, but there's conversation about Evil Shook. I mean, that's how she's referred to in a conversation with the children. She's Evil Shook. They talk about the court lady. I can't tell you if they're talking about me or not, Your Honor, because I think
Evil
at times
Shook.
Vivi thinks I'm a counselor when she sees me. But there's just a lot of conversation about everything but what we wanted these 15-minute phone calls to be to lead up to regular conversation. There's a lot of other stuff going on, but I did reach out to Mr. Black, who was ordered to do the psychological evaluations. Mr. Towns has, in fact, met with Mr. Black. I texted him earlier today to figure out if he had his written recommendations done yet, and I know he told me in a different case that he had some issues with some reports. So I don't have his actual written recommendations, but I do know that Mr. Towns has done and completed. There were some communications with Ms. Hilliard, but then the communications I saw, it wasn't necessarily about scheduling her particular appointment. So to date, I don't have any information that she's done that psychological evaluation where you ordered her to do that yet. I do recommend that there be the psychological and that it is done. I do recommend that at this time the conversations continue to cease, the phone calls cease. I'm going to go a little bit differently than.
So the purpose of this hearing, so what happened was, this is the guardian ad litem. The person we heard before was the clinical therapist. She was the child's therapist. The child's therapist suggested no phone calls with mom. None. Until, they could figure out how to do it where mom's appropriate. The guardian ad litem said, let's at least give her 15 minutes. Let's try to at least give her 15 minutes and see how that goes. This was in January. The purpose of this hearing is the father said he needed an emergency hearing, no more phone calls. The father wants the phone calls completely stopped. That's why we're here today.
Ms. Walsh, who recommended no contact, I do recommend that we continue to have the supervised visits, but they be supervised here at a location, at a facility with a third-party adult who can stop these. If the conversations go out of whack, they can intervene, step in, and stop them. Because the truth is, Your Honor, I would be lying to this court if I said these kids don't want to see their mom. They do. They want to see their mom, but it has to be a healthy interaction, and we're trying to put them in a position where there is a healthy interaction.
Is there such a group, organization in this area that'll do it?
Your Honor, I'm not sure if there's a cost. It might have to be done during the week, and of course, the problem is that Ms. Hilliard, as I understand it, is now working, and she is in another state.
Yeah, mom's in Tennessee, I think. They want only, if they don't have the phone calls, they want only in-person supervised. Mom's in another state. But, I was just about to tell you something important, and then I forgot.
That's right.
But I think that the phone calls leave too much right now because of the way they're going. They are leaving too much. It's just too much.
There's visitation centers that accommodate high conflict, custody cases. There are police stations and visitation centers specific.
I remember. So, yeah, Dad, it's crazy amazing, because this is Georgia. Dad, this all started in, January. It's March right now. So, Dad was able to get this emergency hearing super quick for Georgia. Super, super quick for Georgia. So that's really good. I mean, and this hearing needed to happen immediately. So I'm just super happy that Dad was able to do this.
Designed and engineered for this. It's a no contact procedure, like what I had to do with Robert's ex-wife because of the high conflict. I spoke up and said, none of the children only get out. The adults do not make contact. It's what works best for the children. I've tried to, offer this as well because he just wants control. I don't want any dealings with that. The children can go.
I understand that, but my question was, is there an organization that has the facility that you just described? And I'm not aware of one.
I actually tried to recommend the Cartersville one because it's even closer. It's not even a midway. It's closer to Atlanta. It's closer to him. Then I'll have to travel more, but they have that facility. It's a police station and it's a visitation center.
I'll come back to that. All right, go finish your report.
So, Your Honor, I wouldn't go as far as to completely 100% cease all contact because the girls do, they miss their mama. They want to see their mama, even in the calls where they thought that they were going to see her in Cartersville. You could tell that they were excited about that. Vivi asked her, are you going to come here? But I think it has to be at a facility because there are a number of allegations about Mr. Towns and Miss Hilliard. I've read her.
Maybe we should get that therapist to be our lawyer for this, Bren. Oh, man. YouTube, you're in trouble.
Communications, she has indicated she does not feel safe around him. And in order to kind of handle all of those aspects and all of these moving parts, but to still give these children the ability to nurture their relationship with their mom, I would recommend supervised at a facility in the area that can do it. That way there's an adult that can stop any conversations. It's not over the phone where these children, especially Julie's, trying to figure out what's true or what's not true, things of that nature. And we can maintain some stability for these kids because right now things are just as chaotic. And Judge, now honestly, the calls are going nothing like I anticipated that they would go when I stuck my neck out there and went against Ms. Walsh's first recommendation to put that contact back in
And
place.
Judge,
Hold on, Ms. Hilliard. All right, does that complete your report?
That does for right now, for all that we have been able to gather thus far. I can't give any information on the psychologicals of the parties because I don't, like I said, he did his, but I don't know if she's done hers with Mr. Black, and I don't have either one of them.
All right, Ms. Hilliard, do you have any questions for Ms. Anderson?
Yes, Mel, yes. So what's supposed to happen? Back before, when the children were placed with the father, the judge ordered this woman to get a full psychological evaluation. And that's how it works, Mel. She gets the full psychological evaluation, and then the psychologist gives recommendations on what the mom needs. That's what they're waiting for.
I want to clarify, some matters around my daughter, specifically Julie, but I can do that on my time when I speak. I don't really have questions for Ms.
All right,
Courtney.
anything else, Ms. Schultz?
I would like to ask a couple of questions.
All right.
In the phone conversations that you listened to, were there instances where Ms. Hilliard was directing the children to disobey or defy their father?
Kind of that in a court order that I don't know that they truly know about. There are moments where they're told, you don't have to do that. You don't have to hang up. You can write my phone number down, remember my number, go to school. You can call me whenever you want. That's an unlawful order. There's conversations like that.
Okay. And you indicated that you support Ms. Hilliard getting the full psychological evaluation that has been ordered. Are you aware that she is contending that she submitted to an evaluation in Tennessee?
Yes, I've looked at it. It's a self-report progress note. I see those all the time where you get like a Pineland Mental Health and walk in and it's not a full psychological assessment that we anticipate or the court's looking for.
So is it fair to say that that report she provided from Tennessee does not meet the recommendations of what you think is needed in this case?
No, a full psychological is going to take into account, collaterals from all other places. But I know that in doing Mr. Towns, Mr. Black took collateral information from Mrs. Towns. It's really in-depth and fully so we can get a true idea of if the parties have any diagnoses. Sometimes we go in for these, hey, I want to check my mental health assessment type things, and we go in and see a practitioner and get a progress note, and it's based on 100% self-report, and that's not the type of document we were discussing.
In this case, initially, the judge signed an order appointing you, and in his initial order, he ordered that each party was to pay you the amount of $375 for guardian ad litem fees, and then that order was amended to provide that you were to be paid $1,500 in guardian ad litem fees by each party. Is that correct?
That is correct.
And those orders were dated, the original order September 8th, 2025, and then the amended order on September 15, 2025, correct?
That's correct.
To date, have you been paid 1 penny by Ms. Hilliard for any of the guardian ad litem fees that were ordered?
I have not.
Okay. And we previously came to court on the motion for contempt that was filed, and the judge reserved ruling on that contempt. Is that your understanding?
On the motion for contempt, yes.
Okay. And since the judge reserved ruling, have you made efforts to communicate with Ms. Hilliard about paying your attorney's fees?
We've not been paid. I've been paid $1,500, and as of this morning, before I got in the car to come over here, we checked the bill, and the bill was over $5,000, and that's not, we would have to subtract what Mr. Towns has already paid from that. So we've just kind of basically been working for the court for free, just because I know the importance of this case.
What has been Ms. Hilliard's responses to you when you've tried to get her to pay your guardian ad litem fees?
That the court has essentially reserved ruling on that fact, and she has made several statements that she didn't, you basically said she didn't have to pay it. That the court said that she didn't have to pay it.
And in response, did you advise her that that's not the situation and that there is still an order requiring her to pay?
I did.
And what was her responses in that regard?
It is still that the court reserved ruling, and that's something that will have to be taken up at a different day. And contrary to what most attorneys would have done, which is done nothing, in this case, we continued to work like we would normally work, because what happens to these little girls is important.
I'm going to show you what I'm marking as plaintiffs 3, which is an email chain between Ms. Hilliard, myself, and you, and ask you if this is a copy of the email conversation that we had with Ms. Hilliard around January 30th, 2026, in an effort to, one, get her to pay the monies owed, and in regards to the psychological evaluation.
Yes, this is it. This change started back on the 29th. Ms. Hilliard sent an email to me, and I believe you asking me for formally request a copy of a guardian ad litem report, and I was explaining to her that I've not written an actual physical report. I sent an email to the court as I was directed to in September, and she was CC'd as a part of that email. But in that email chain, I also asked her about, please remit her half of her guardian ad litem fees, so that we can,
Ms.
and
Courtney?
sent several reminders.
Ms. Courtney, didn't I reach out to you
Hold on.
right when you were
Hold on, Ms.
assigned?
Hilliard. You'll get your chance. Hold on.
Okay.
All right, go ahead, Ms. Hilliard.
And did that email chain that occurred between those 2 days also address the status of her taking her psychological evaluation through Darcy Black and Associates?
We did. We talked about that in the email chain, and then at one point I did ask her to provide me an update. She did ask me again about the guardian ad litem report. I clarified to her again that there was not a physical report. I've not submitted a final written report to the court other than that email I sent to the court about my recommendations. That was all that was there. And that when I do a final written report, everybody gets it simultaneously. And so then there was some more back and forth about the contempt and the judge reserving ruling and whether or not it had to be paid. And at some point in the email chain, I think I emailed, if I remember correctly, and just kind of, said respectfully, have a good day. That is my cue that I wasn't going to continue to go back and forth about it. But then there was continued back and forth emails with you and Ms. Towns about it.
And the end result of this email conversation is that Ms. Towns' opinion is that she did not have to pay the guardian ad litem fees to you until some judge issued an order otherwise telling her that, and that she was not going to pay it until there was an order, and she was not going to participate in the psychological evaluation because she feels like the Tennessee one complied with the order.
Basically,
Okay?
loosely worded.
Not
yes.
worth over.
Okay? You gave that to the judge already? Okay. Are you aware that Ms. Hilliard sent, well, let me back up. Do you have concerns about Ms. Hilliard trying to intimidate witnesses in this case?
Yes.
Tell the court about those concerns. What causes you to have those concerns?
It's just been silly stuff. There was, I've seen
Who is speaking?
Hold on, Ms. Hilliard.
Ms. Anderson is speaking.
So I've been privy to the social media posts and all that. I've reviewed all of this stuff in this case as well. There's been things like after Ms. Walsh sent that letter, there were angry face emojis. I guess on social media, Facebook in particular, you can like or dislike a post. And in Ms. Walsh's, several of her posts on her business page and whatnot, you would have just one angry face.
Thank you, V. Thank you so much.
I
I do
don't
need them.
I guess probably a like or a comment, and it would be Miss Hilliard. I had them, I've got a rental company that's owned by my son, my 7-year-old, and I was advertising one of his properties for rental. We woke up one morning and we had a random angry face, and it was Miss Hilliard. We had a random social media post on my business social media page. It was very long, about a bunch of stuff that happened prior to me essentially even getting in this case and how she lost custody of her kids. There was an email to Dr. Tom Black, and in the email in particular, Dr. Black and I were involved in a Wayne County case that had a lot of things going on, and the mother, we ended up all over social media, in particular in the email response that Ms. Hilliard sent to Dr. Black. She made sure to tell him that she was having lunch with her family friend, who was Dr. Odom, who is the mother from that case in Wayne County where there were issues. And so it's things like that to kind of, that I have concerns about. Now, I could, obviously, I have no ill feelings because I'm recommending that she continue to see her children here over the objection of Ms. Walsh still. So I don't have any ill feelings about that stuff. I don't care about that stuff, but it's things like that that are happening that I have actually seen happen in this investigation.
All right, anything else, Ms. Shook?
Give me just a second to look at my notes, Judge. Can I do all these with her? Nothing further at this time.
All right, I need to take a quick break, so we'll take a 10-minute recess.
He called her Miss Shook, but I like Evil Shook better.
I'm gonna mute everything and everybody. I'll be back in 10 minutes.
Okay.
I cut out a part of it because he forgets to unmute. So they'll be midstreamly come
I
back.
had myself muted the whole time. Okay, sorry about that. All right, Ms. Hilliard, let's get back on the record. Ms. Hilliard, we've been going for a pretty good while here, but the issues before the court today are the requests by the plaintiff to suspend the phone visitation, the telephone calls, and the in-person visitation, and the contempt issues that have been set out by Ms. Shug, and of course, Ms. Anderson's report and recommendations. So what is your response to all of that, Ms. Hilliard?
Well, thank you, all of y'all, for your time. My girls, the best interest is all I care about. They need their mother. I'm a good mother. I acknowledge. I wish I had a lot of money and you all could have it all, but I don't. I have 5 children. I would like the court to acknowledge I have other children, my 13-year-old Ryder, my 2-year-old Wild, and my 10-month-old who I'm still breastfeeding, Seal. Those are my babies as well. When Ms. Courtney was assigned, I initially, as I have did always, reached out to her and made contact. She had to reschedule. There was twice she had to reschedule, and that's what I was going to verify with her because, I was ready to pay whatever and get things going. But then once I seen how the things that were being twisted, like with Julie, and as it was very much stated here today, how y'all wanted to highlight her, I started, trying to explain. Julie's seen a lot more when she was younger between me and her father that she shouldn't have. It affected her greatly, and I'm very protective over her because of that. I don't appreciate how she was displayed here today, and she's behind in reading, and her vocabulary and all that has been well known, and we have been working on that up here. That's why she was, in the IEP, that's why she was in the program she was. She had a one-on-one every day. I went monthly to these meetings. We went over everything, and she was progressing. She was doing remarkable. So, the assertions that she was not, and the score level that she was on, she doesn't do good in the anxiety and all with testing. She will never do good in, because of everything she went through when she was little and what she's seen. She's has a lot of energy and all, and that I try to work with her to focus that, but I reached out. All my attempts have been, willful, as exactly as I should have done. I never said I would not pay. I did not think I had to pay. I never said any of those things. I've actually done everything I was supposed to. All my filings have all the communications, all the documents, even to verify the inconsistencies in the case on the opposing side. The inconsistencies there alone is enough for a dismissal, in my opinion, but, I'm just a mother. I don't have much experience there. But I haven't, my babies are in the best care with their mother. I have never harmed them, never would. I don't know how we're on this route where y'all think taking a mother away from their babies is in the best interest. Yes, I regret in the beginning my triggers, but I don't think any of you could imagine what this feels like. And I don't want you to, but I want my babies home. I want my contact back with them. That's in their best interest. And that's really all I have to say about any of it. When I get the money, you will get paid. It's just really sad that it boils down to that. Because that's all y'all really have, is that I can't pay these fees when I've even documented, I didn't even ask for child support from Robert, but when I had to get divorced, they took it out. It was only $200 a month, and he refused to pay. I have those documents of that, where they had to purge them twice after 3 months, 6 months in total before I moved, because, he wouldn't pay a little $200. I didn't need it. I didn't ask for it. But now y'all are coming at me like I'm the one, that's in the wrong because I can't pay these astounding fees. But if the psychological evaluation is needed, I'm not opposed to that. I've reached out to Black as well, right when that order was done, and had communications with him. From my knowledge, Robert hadn't had his psychological evaluation either. So using that against me, I don't think is right. But I'm not opposed at all whatsoever to such. I just, I want my babies home. In my opinion, this is just a matter of my ex's control. Once he knew I was moving, he couldn't do what he has always done, and this is the outcome. And it's not right. My babies, they deserve their mama, and I deserve my babies. If I have acted ill towards anyone, I am genuinely sorry, because that's not me. And I'm trying to keep my composure, but Pointer, I think that is all, though.
Well, Ms. Hilliard, you're absolutely right about one thing. Whether you know it or not, you correctly stated the legal standard, which is best interest of the children, which is my sole obligation here today. Any other issues are secondary to that. Now, Ms. Hilliard, I understand everything that you've just said, and I'm not insensitive to what you said, but you have completely ignored the testimony of Ms. Walsh and Ms. Anderson. And the court finds the testimony of Ms. Walsh and Ms. Anderson to be more than sufficient to grant the motion on an interim basis, or at least until further order, to suspend all telephone calls with the children and the visitation, unless the in-person visitation unless through Ms. Anderson, you can find some suitable location and organization that will provide all of the protections that you yourself have requested, Ms. Hilliard, as well as Ms. Anderson. Now, I don't know who that could possibly be.
Judge, we had worked out to have Mr. Bobby Solomon actually do one of the visits before the order got signed, and then that didn't happen. But Ms. Hilliard never confirmed with me whether she was in agreement to be supervised by Mr. Solomon. We were going to do it at the park, here, the state park here, with Mr. Solomon present. And of course, that was going to require payment of money to accomplish, which my client was going to pay Mr. Solomon to do. I'm not certain whether she's in agreement to do that or not, because she never confirmed that she would or wouldn't.
Well, hold that thought. I don't want to get everybody in this room or attached to this case having to wait on me to make a decision. The court is prepared to authorize Ms. Anderson to facilitate such things so you can get a quicker answer, all right, instead of waiting on me to do an order. But there are going to have to be some safeguards. They're going to have to be supervised. And Ms. Anderson, good luck. I don't know how that's going to possibly work out. But you yourself have recommended that, and that's fine with the court. Now, that leads to the next couple of issues here. Now, Ms. Hilliard, right, wrong, or indifferent, you are in contempt of court. Now, I'll leave for another day the willfulness, but this court ordered you to complete a psychological and to pay these fees. Now, they've not been paid. That puts you in a very precarious legal situation. At some point, the court may reconvene to determine willfulness, and at that point, the court can take some rather uncomfortable and very unpleasant actions. In regards to the contempt, but it is not open to dispute.
When did Robert pay his?
No, Ms. Hilliard, now I gave you the chance to talk, my turn to talk. You simply don't have a choice about complying with the court order. Now, there is an order for you to complete your psychological. If you don't want to complete it, so noted by the court. These fees, payments, they've been ordered. They've not been changed. The bill, the meter's running, and it's not going to stop until this case is concluded. And you comply with them at your peril, or excuse me, if you don't comply with them, they are at your peril. Now, how this case moves from here, that's an open question. That's a good question. I can't tell you as I sit here right now how this case is going to move forward. Ms. Anderson has the complete confidence of the court is to try to find some way to move it forward, but until I get another report from Ms. Anderson, the relief requested is granted in the motions. As previously stated, you're going to get me an order?
Yes, Your Honor.
What else do you need from the court to prepare an order, Ms. Shook?
Judge, the issues for today was the emergency motion to modify the visitation, which the court's already addressed. The contempt as it relates to the $5,000 in attorney's fees owed to Mr. Towns or to me that was ordered back in
Last year, yeah.
in June or May of 2025. The guardian ad litem fees of $1,500 owed to Ms. Anderson. And then my most recent amended was in regards to the psychological evaluation and the inappropriate phone calls. And again, I was asking for attorney's fees as a result of all of this. In addition, in my motion to modify the interim order,
I know the judge gave his ruling. No more calls, period. So we think it's over. There's still more.
I also requested child support to be ordered because currently there's not been any order for her to pay any child support. And so that was an issue before the court today as well.
Well, I don't think Mr. Towns has any reasonable expectation of receiving child support, but it is required by law to be addressed by the court. But again, I'll leave the willfulness issue to another day, but include it in your order, Ms. Shook, along with everything else you just said. And I'm going to leave Ms. Anderson to try to find some method to move forward. Unless you have a suggestion to me now, I'm going to just leave it to you and to your best efforts to try to work something out.
Your Honor, as I sit here and think, I would recommend just placing in the order that Ms. Towns will be, Ms. Hilliard would be entitled to supervised visitation at any TLC CASA location. That gives a number of counties between that, where they go, Dublin, Blakely, all the way down to wherever that can
Well, I'm
do
going to let you work
visitation.
with Ms. Shook and Ms. Hilliard about,
He just granted child support. I don't think he said how much, but he granted it. But he said he's never going to see it. This woman is never going to pay.
where, okay? But as long as it meets the criteria that we have been discussing, but until we come to some specific spot, the visitations are suspended.
Well, Your Honor, I would ask this for the court to make this particular decision. What city or what area of the country do you want these visits to take place? If the court can just rule on what area, I think we can narrow down the rest of it. I have read emails.
I don't
Ms.
even know
Hilliard's
where
requested,
Ms. Hilliard lives, except the paperwork I saw said Sparta, Tennessee, but I don't know
Yeah.
where that is.
she's requesting visits in North Georgia, Ms.
Man.
Shooks, per the email.
Nan, she's living with you? Come on, Nan.
Was requesting they stay in the area. If the court can give me an area.
All right.
And will rule on the area, I will make the rest of it work, Your Honor.
Judge, my rationale in requesting that the visits be in Telfair County area is that Ms. Hilliard is from here. She has family here. And so my thoughts were she could drive down for the weekend, stay with her family members, which wouldn't cost her any money to stay.
I have a 2-year-old and a 1-year-old.
And then we could do a visit and she could go back. So that was my thought process.
Well, I can tell you this, it's not going to be one of these halfway things. I don't know of any place in the Oconee Judicial Circuit where you can do it, so I
Mom's about to have a mini meltdown. Not a huge meltdown, a mini meltdown, but oh my.
think it's going to be Dublin, I guess, Vidalia, I don't know, but I would say.
So y'all are forcing me to come to Telfair County to see my babies, and I have no right.
Hold on, Ms. Hilliard, or a neighboring circuit, that's the best I can tell you at this point. So I'll give you that geographic restriction.
Oconee Circuit or a neighboring circuit?
Yes,
Yes, Your Honor.
all right. Now, Ms. Hilliard, I know that's not what you wanted to hear, but as I told you before, my interest, the best interest of these two children, and that's what I'm going to do, whether you like it or not. That's my role.
Judge, I don't mean to beat a dead horse, but the plaintiff's 3 that was tendered, the email conversation where
Yes, I have it here.
we were trying to get Ms. Hilliard to understand that she had to pay the monies and do the psychological evaluation, she was flat refusing unless she got an order by the court that was unambiguous and requiring her to definitely do these things. So I want her to be extremely clear on what the court's order and ruling is on paying these monies and getting this psychological evaluation, if the court would make that as clear as the court can.
Hold on just a second.
Just write up the paperwork to sign all my rights over, because I'm not fighting this fight with my abuser. I'm not doing this. Y'all are not forcing me to have contact with my ex-husband. Just sign up the papers I'm giving up all my rights, and this is over with. This is done. When they get older, they'll come find their mama. And shame on each of you.
She whipped out the
Are any of
shame.
these jury trial issues, they
I mean, in theory, child support could be, but I've not demanded any jury trial.
No, everybody just
But
ignored
that
her.
would be the only
No one
issue, I
listened to
think,
her
that
there.
could be a jury issue.
Don't I, hold on a second.
Y'all have my email for all the orders and documentation.
Well, I thought I had a Telfair civil term. As I sit here right this minute, I don't think any of these issues are jury issues, but I'm going to take a look. And the point I'm beating around the bush about is this case has been pending for how long? I know it's a 2025 case, but when was it filed?
We first had our first hearing in May of 2025. I think it was filed around February or March of 2025.
So we're right at a year?
Took me a little time to get service on her.
Yeah. Okay.
Because I was a resident of Tennessee.
Oh, and that's another thing I would like the court to
Hold on,
address.
Ms. Hilliard. What I'm beating around the bush about is that this case is bumping up on being a year old, and it's time to set a date for a final hearing or a jury trial if any of these issues are jury-related. Again, I don't think so, but I'm going to have my staff attorney look into it. And what I'm trying to say is it's time for the court to set a date for a final hearing and get this matter closed.
I would agree, Judge, but we've been waiting on the psychological evaluation, which we still don't have. And I do want to address the jurisdiction issue. If the court will recall, I sent an email in the last couple of weeks regarding Ms. Hilliard's actions in trying to get Tennessee to take jurisdiction of this case. There are previous orders in this case where the court has addressed the issue of jurisdiction. This court has asserted in the orders that Georgia was the home state of the children, but for the fact that Ms. Hilliard removed them from the state of Georgia and took them to Tennessee. And the court indicated that Georgia is the home state of the children. This is set forth in the orders signed by this court and filed. And Ms. Hilliard has filed an action in Tennessee with the courts there, trying to modify this court's orders and trying to get the Tennessee courts to take jurisdiction of this case. That is resulting in my client now having to pay an attorney in Tennessee to litigate that issue that's already been litigated in this court. Additionally, she filed at the point in time early in this case, she had Sarah Riedel as her attorney. And Sarah filed a motion to vacate the order, and Sasha Knight came and argued that motion. I have the transcript from that hearing. That was on June 25th, 2025. In that transcript, you asked specifically about jurisdiction and whether they were challenging jurisdiction because there had been some comments made that she was a resident of Tennessee. And Ms. Knight's response was, quote, "No, Your Honor, we are not challenging jurisdiction. Pursuant to the UCCJEA, Georgia will retain jurisdiction." So there are transcripts that say Georgia is the appropriate jurisdiction. There are orders that say Georgia is the appropriate jurisdiction, yet Ms. Hilliard is going and filing stuff in Tennessee that's now requiring my client to pay thousands of dollars to another attorney to take care of his rights and defend in Tennessee. And if the court could reach out to the judge in Tennessee, have a conversation about jurisdiction and, remedy that for us, that would be great.
I think that's actually required in the UCCJEA, isn't it?
It is. And
Who it is?
I don't know, but I will certainly find out.
What county and where?
It's White County Chancery Court in White County, Tennessee.
got you.
And so if the court could reach out to the judge in Tennessee and say, hey, this has already been litigated, and Mr. Towns filed a pro se response, which listed and provided as exhibits those appropriate documents evidencing this. And I would just ask that if you could help us do that before he has to pay the Tennessee lawyer, that would save him thousands of dollars.
Well, I do believe that is specifically authorized in the UCCJEA, but, Ms. Hilliard, you may be needlessly expanding the scope here, and all these actions, they're going to come home to roost one day, and I can tell you they're going to be very expensive, Ms. Hilliard. What you're doing is going to be, you're going to regret it. I can tell you that before it's all over.
Everything that she's making him spend, I'm going to be asking for in attorney's fees to be paid back to her, or to us, before this case is over.
How are y'all doing this? He did not help me with my children any. He didn't even pay child support. How do y'all think this is okay? When he found out I was moving because he did not help or have any involvement with my children, that's when he is trying to portray this persona that he was an involved father. He was never an involved father. How are y'all trying to make me to be a villain and Julie to be so troubled when that is not the truth here at all? Y'all are causing my babies irreparable damage, and y'all are acting like it's okay and that's justice for them.
All right, Ms. Hilliard, that's not before.
That is not right.
All right, I've muted her. This matter is concluded. Get me an order.
Your Honor, the only other thing is, while the court was in recess, we could still hear from inside Ms. Hilliard's home, and I believe there was some conversation about recording, and that is not allowed, and so I would ask the court to address any potential recordings made. We're not allowed to record as attorneys. The only official recording is the court reporter.
Well, Ms. Hilliard, again, if you are recording this proceeding, you're wasting your time, first of all, because it's already being recorded by Zoom and by the court reporter. So you're putting yourself again at peril for something that is pointless, because you can get it, I'm not going to say for free, but you didn't have to do that if that's what you're doing. I don't know if you were or not, but you're violating this Uniform Superior Court rules. And again, Ms. Hilliard, you're putting yourself in serious jeopardy of serious repercussions. So you've been warned multiple times, Ms. Hilliard, but that's it for today, Ms. Hilliard. This proceeding is concluded. Thank you all.
Thank you, Your Honor.
We need something to wash that down with. We need a dessert. We're gonna do all right, we're gonna do this one. It's quick and easy. It's Judge Fish. That's how we're gonna end the day.
Marcus Simmons, state, would you please start a record? Yes, Your Honor, thank you. This is State of Indiana versus Marcus Simmons. There are two cause numbers, 64D01 2512F614129 and 64D01 2603 CM2364. Defendant appears in court in person, by video conferencing without counsel. State of Indiana by Gary Gurman.
Hey, Judge, can I say something before we start?
No.
Okay.
Best call for you is to pay attention to what I say.
Okay, Your Honor.
And respond to my prompts.
I respect that.
Well, he's thinking I forgot to say Happy St. Patrick's Day, guys. I can't wear green. Every year I try to put green on for St. Patrick's Day, and green screen, can't do it. I can't wear anything green, light green, dark green. So, but it is St. Patrick's Day, and it is time to start drinking. So you should already have a little bit of alcohol in you. Please do not finish this day alcohol-free. Think of all the poor Irishmen out there who need, every drink you take, an Irishman gets a little stronger. That's facts. That's 100% true. You have to prove it's not true for me to believe it's not true. Happy St. Patrick's Day.
At some point, my screen will inform me about all the things I need to know.
No problem. I was hoping someone would say
Okay,
that.
Mr. Simmons.
I knew someone was going to say that. Actually, knew you were going to say that, and a couple other people. If you don't drink, don't worry. I got you covered.
On March the 4th, probation filed their petition for revocation of administrative probation. In it, they allege that you violated Rule 1, that you failed to sign the administrative rules of probation.
My mom,
They
she never,
also say, hey, like I said, Mr. Simmons, what's important is for you to listen to what I say and respond to my prompts.
No. You got to listen to what Tina said first. No alcohol, but corned beef and cabbage. Oh, yes, sir. Yes, sir.
I haven't prompted you to make any response back to me yet. Okay?
I'm sorry.
Okay. So you're already going to try to talk about what they allege. That's also not a good idea for you. What's important is for you to listen to what the allegations are and simply respond to my prompts to you. Okay?
I'm sorry, Your Honor.
Okay. I just want to make sure you're clear on what I need from you.
I'm sorry, Your Honor.
They say you violated Rule 1, that you failed to sign the administrative rules of probation. You understand what they allege?
Yes, Your Honor.
Okay. And then they say you violated Rule 2, that you engaged in criminal conduct. They say you were arrested for possession of marijuana, and that is in the CM 2364 cause number before me now. Do you understand what's there?
Can you repeat that, Your Honor? The audio went out.
It says that you were arrested for possession of marijuana. Do you understand that?
Yes.
Okay. Well, if it's found that you violated your probation, any part or all of your previously suspended sentence could be imposed as jail time. Additional conditions could be added to your probation, or an additional length of time added to your probation. Any or all of those may occur if it's found that you have violated. Do you understand that?
Yes, Your Honor.
In a revocation proceeding, you're entitled to a hearing. At that hearing, the state would have to prove by a preponderance of the evidence that you actually violated your probation. Do you understand that?
Yes, Your Honor.
At that hearing, you'd have the chance to confront and cross-examine witnesses, and if necessary, use the court's subpoena powers to have witnesses brought here to testify on your behalf. Do you understand that?
Yes, Your Honor.
You're also entitled to an attorney. If you can't afford an attorney, one could be appointed for you. Do you plan to hire counsel?
I can't afford one.
Did Judge Tody or Drenth talk to you about counsel yesterday?
No.
Okay.
Yeah.
All right. Are you asking me to see if you qualify for the public defender?
I don't have Tody anymore, Your Honor.
Are you asking me to see whether you qualify for the public defender, sir?
Yes.
Okay. Please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, Your Honor.
Okay. What do you do for work, sir?
I don't work. I don't have a job.
Okay.
I'm currently homeless.
You can put your hand down. What were you doing before? Have you ever worked?
I haven't worked for 3 years. My mom's been taking care of me. My mom she has been taking care of me. I ain't got nobody for her. I don't got no money. I don't got nobody for her. I don't have nobody. I'm staying with my mom right now because she's all I got. Huh?
Do you have any kids?
No.
All right. Do you own any property at all?
Martha, thank you so much for the 6-month subscription on Twitch. I appreciate it. Martha's using her Prime. Okay, so if you have Amazon Prime, you automatically get to subscribe to one channel a month for free with your Prime account. You have to do it every month, though. If you take that and you subscribe to my channel on Twitch, you can watch the live stream as it's live with no ads.
No, I don't own nothing.
How do you get around?
With my mom, she takes me to get around places.
Yeah.
To stores
Okay.
and stuff like that. Yeah.
I'll find your indigent, you qualify for the services of the public defender. I'll appoint the Porter County Public Defender Service to represent you. And I will set you over for a hearing on March the 27th at 9 a.m. We'll hang on to you. See you back on March 27th at 9. You're ordered to appear back here at that date and time. You understand?
Yes, Your Honor.
Okay, we're adjourned.
He kept them.
Thank you. Mr.
Keeping
Webb,
them in
State, would you
jail.
please set her?
Yeah, I have YouTube Premium too because I can't do ads. I mean, we grew up with ads. We are okay with commercials. But I don't know, I can't do YouTube commercials. None of the ads fit me at all. None of the ads is anything I would ever purchase in any way. So, I can't do ads. But I do ads on my court disorder is not premium. So whenever I watch anything when I'm court disorder, I watch ads. And they're so stupid. None of them have anything to do with me. I do appreciate ad campaigns that are targeted. I do. I know people, at first really didn't like it. But I appreciate ads that have something to do with me, that I can have some interest in. I don't need hair loss drugs. And I never will. If I lose all my hair, I'll just be a happier person. But anyway, that's what we got for today. Tomorrow's Wednesday, so 2 streams tomorrow. Go drink some orange juice. Get your vitamin C in so that you have stamina. And go get your sausages with an attitude. And some mashed potatoes. Bangers and mash you can eat. That's perfectly fine if you don't want corned beef and cabbage. Corned beef and cabbage. I do appreciate good beer ads. They're funny, they're entertaining, and they make you want to drink beer. So, yeah. What's wrong with that? Those are good ads. I don't ever get chocolate ads. Like, that would be perfect for me. Alright, guys. Behave, be good. I'll see you again soon. Thank you so much. I appreciate it. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. so in